first let's start with good faith, the first principle, which is good faith. Now, what is the meaning of good faith? Good faith means you are supposed to disclose every material fact to each other. Both the parties should disclose every material fact to each other. What is the Latin maxim on which it is based? It is called "Uberi mea fidel," right? And also, both the parties should observe utmost good faith, and they should disclose every material fact known to them to each other, right? Now, in the case of good faith, the burden of proof lies on the insurance company, right? It lies on the insurance company. Now, one more thing is that this good principle of good faith or duty of good faith is continuing in nature, which means कॉन्ट्रैक्ट के पहले भी और कॉन्ट्रैक्ट के साथ भी, right? At the time of making contract and also during the contract, you have to observe good faith. Now, coming to the next principle, which was misrepresentation. So, what is the meaning of representation? It is a statement made by one party to another, and if the representations are an integral part of the contract, then the representations or the statements, they become warranties, right? And we also studied three conditions which are important for willful misrepresentation, right? So, okay, G Renuka. I think this is G Renuka. Yeah. So the first condition is that statement must be on material matter and it must suppress the facts which are supposed to be disclosed, right? The statement should suppress the real fact, right? Whatever is the fact, it should suppress that, and it should suppress the materiality of the fact, right? And the next condition is that suppression must be made fraudulently by the policy holder, or we can say it must be done fraudulently, or obviously we are studying misrepresentation, so obviously fraudulent suppression must be done by the insured person. And the third condition says that policy holder must be aware at the time of making the statement that it was a false statement, right? ऐसा नहीं है कि it should be like you spoke something in an intoxicated condition, and later on they filed a suit against you regarding that statement, right? It should be in such a manner that the policy holder should be aware that yes, I am making this particular statement which is suppressing the fact of the thing, right? Now, these are the three conditions of willful misrepresentation. Now, coming to warranty. What is warranty? Warranty is a promise where the assured or the insured or the policyholder is undertaking that some particular things shall be done, or some of the conditions must be fulfilled, or some of the facts can be affirmed, right? Now, breach of warranty can lead to avoidance of the policy. Whether the promise which was broken, whether it is material or not, it doesn't matter. But yes, if you are breaching the warranty, then your policy will be avoided. Now, the breach of warranty can be expressed or implied, right? Now we are talking about conditions. What are conditions? Conditions are basically the restrictions or limitations under which an insurance policy is granted, right? Now, uh, when there are two parties, insured and the insurer, both have certain duties, right? So, in the case of conditions, we are talking about the duties of the assured or duties of the policyholder, right? Now, what are how many kinds of conditions are there? Subsequent and precedent. What is precedent? These are essential for creation of a valid contract, and subsequent conditions are after the contract is created, you have to continue the valid contract, right? So to continue the validity of the contract, you need to follow the subsequent conditions, right? Now, the next was indemnity and subrogation. What is the meaning of indemnity? It means protection against loss, right? So, other than your life insurance or your personal accident insurance, all the contracts are contracts of indemnity. Why we are excluding these two things? because in case of life insurance, whatever event is insured, that is your death, right? Death of the insured. So once the person has died, you cannot get that person back, right? So here the principle of indemnity will not work, right? Now, in case of personal accident also, if you have to get rid of one of your body parts in the accident, then obviously you cannot get that back, right? Now, what is the like practical meaning of indemnity in this case? The insured is to be placed, the second point, the insured is to be placed in the same position as if the loss has not occurred, right? Like whatever was the condition of the insured before the occurrence of that particular event, whatever was his position, you have to replace the person in the same position, right? We are talking about financial loss in this case. Now again, certain limitations are there in case of indemnity, that the obviously the injury or the loss sustained has to be proved. The second point says that whatever amount is specified in the policy, you are going to get a cover, or you're going to get a amount which is limited to that much amount only, right? Whatever is specified in the policy. Now, indemnified only for proximate or exact cause. So this particular principle we are going to study today. And the last condition says that market value of the property determines the amount of indemnity. So whatever amount specified in the policy and market value of the property, whichever is lower, that amount you are going to get as the cover for the insurance, right? Now we are talking about principle of subrogation. So subrogation means when one party stands in for another. So in this case, we are taking an example of this. Mr. X is there who is sending some of his goods to another place, and the truck in which he is sending his goods are owned by a transport company, right? Now, for example, this truck met with some accident, and Mr. X had to suffer a loss of rupees 5 lakhs due to the driver's fault, right? So in this case, what happens? The insurer means the insurance company from where Mr. X has got the insurance. So that insurance company can collect rupees 5 lakhs from a transport company. This signifies what? This signifies that the principle of subrogation enables the insurer to take over the policy holder's legal right, राइट, लीगल राइट. सो इंश्योरेंस कंपनी, ऐसा नहीं है कि इंश्योरेंस कंपनी आपको जितना भी है आपको सब देता फिरेगा, राइट? सो इंश्योरेंस कंपनी ऑल्सो हैज़ टू गेट अ वे आउट, लाइक फ्रॉम वेयर वी कैन गेट द मनी बैक. So that enables, so this particular principle enables the insurer to take over the policyholder's legal right to recover the damages, right? I hope this is clear. Now, this is something which we studied in the last class. Now we are starting today's class. So the next principle is principle of proximate cause. Now, the Latin maxim on which this is based is called causa proxima non remota spectator. This one, okay? You don't need to remember this. I've just written this here so that I can teach you in a better way, right? So this particular Latin maxim says what? Proximate and not the remote cause shall be taken as the cause of loss, not the remote cause, and only the proximate cause shall be taken as the cause of loss. Here also we have studied the same thing. So what is the meaning of proximate cause? Proximity means क्या होता है? Proximity means closeness, right? Closeness. He's very proximate with me. That means he's very close to me, right? So proximate means directly or indirectly, but whatever is the cause or whatever is the reason of that particular loss, it should be proximate, it should be clear or proximate with the thing which is written in the policy, right? Which means if I have taken insurance for like if my phone if I lost my phone somewhere, then in that case I can get insurance from the insurance company. But somehow I broke my phone, So in this case, this is not going to be a proximate cause, right? This is going to be a, like this is a remote cause. This is not the exact cause for which I had taken the insurance, right? अगर मेरा phone कहीं गुम हो जाता, then only I will get the insurance money, right? So this is the same thing. Proximate means directly or indirectly, but it should be clear and proximate. Proximate means exact. Now, when we are talking about proximate cause, then the burden of proof that the loss occurred on the account of proximate cause, it lies on the insured person only. So when you have taken the policy for a particular thing, for example, if I lose this phone somewhere, then in that case I am going to get the insurance money. So in this case, I have to prove to the insurance company that yes, I lost my phone. Like I have to prove, like the burden of proof lies on me, right? Obviously the insurance company is not going to search कि इनका phone सच में गुम हुआ है कि नहीं, right? So in this case I have to prove that yes, whatever thing for which I was supposed to get insured, that particular thing has occurred, right? I hope this is clear. Now, Marine Insurance Act says that insured cannot recover for a loss where his own deliberate act is the proximate cause of it. Which means, for example, I knowingly lost this phone. Like I was, suppose I was I kept it somewhere and I forgot that, right? And I thought that I lost my phone. So in this case, what happens? This is my own deliberate act from which I lost the phone. So in this case, I am not supposed to get a recovery for the loss, right? Now, the next and very important principle is that insurable interest. Insurable interest means uh, the person who is an insured or the person who is making a policy, that person should have some kind of interest in the life or property for which he is getting the insurance done, right? For example, I can get a life insurance for my father, but I cannot get a life insurance for a stranger, because in case of life insurance for my father, my own insurable interest is there, my own insurance interest is present, राइट? बट ऐसे ही किसी राह चलते लोग आदमी का मैं नहीं करूँगी ना, बिकॉज आई डोंट हैव एनी insurable interest for that particular person, right? So here it says that insurance contract is valid if insurable interest is present there, right? Then only it will be valid, otherwise it will not be valid. Now, policyholder must establish some kind of interest in the life or property which is to be insured. In the life or property which is to be insured. Otherwise, insurance policy will be void. Right? Obviously, insurance policy will be void without insurance interest, because it doesn't really make any sense. Right? Now, the next point says, what is the test for insurable interest? Like, how will you measure that, yes, this person is having insurable interest in this particular thing? So, the test says whether the insured will suffer any pecuniary loss in case of this particular event or in case of this particular loss. So, pecuniary loss means, it means financial loss, right? Monetary loss. So, now uh, for example, I did an insurance for my own phone. So here I have insurable interest for this phone because this belongs to me, right? Now, if I lose this phone somewhere, then in that case, obviously I'm going to suffer some financial losses, right? So in this case, insurable interest is present. But when we are talking about life insurance, like listen to this very carefully, this is very important. When we are talking about life insurance, so in this case, what happens? In this case, like for example, my father has done LIC for me, right? So that is for my life. Now if if something happens to me, then my father is obviously not going to suffer any pecuniary loss, but this is this is dependent on the nature of that insurance. In case of life insurance, we are not we are not suffering from any pecuniary loss, but yes, in this case obviously we are suffering from a loss, but pecuniary loss is not present there. So it says that insurable interest varies depending on the nature of insurance, right? In case of health insurance also, in case of life insurance also, even though we are not suffering any in pecuniary or financial loss, still in this case what happens, uh, we can test insurable interest depending on the nature of insurance, right? Now, so basically, in when it comes to the principles of insurance law, there are seven principles of insurance law which we have covered till now. But in our ICMI book, two more extra points are given. So let's study those 2 points. The next point says that insurance and consumer protection. You all might be knowing that there's an act called Consumer Protection Act. I don't remember the year. So insurance companies are not consumers. They are not consumers according to the definition which is given in Consumer Protection Act, right? They are obviously not consumers because they are providing something in consideration. The insurer cannot be regarded as any beneficiary of any service, right? uh, in case of any service, the insurance company or the insurer cannot be regarded as the beneficiary. Now, remedy available to the insurer is to file a suit in a civil court for recovery of loss. Now, if the insurer suffers any kind of loss due to the fault of the insured person or the policyholder, so in that case, what happens? The only remedy which is available to the insurer is that he can file a civil case, he can file a civil suit in the court for recovery of loss, right? So that is the only remedy which is available to them. Now, the last thing that we have to study in the principles is that commencement of policy. When we are talking about commencement of policies, so we know that in Indian Contract Act 1872, we have studied that for a contract to be valid, for an agreement to be valid, there must be an offer and there must be an acceptance, right? When these two things meet, then only the agreement becomes valid. And whenever the agreement gets enforced by the law, it becomes a contract, right? The same thing is applicable here also. uh, for an insurance contract to be valid, you need to have offer and you need to have acceptance, right? So now there are two parties involved in insurance contract, right? One is your insurer and the second one is your insured. So one person has to make an offer, and the final acceptance or the last acceptance can be done by either parties. It can either be done by the insurer or it can either be done by the insured, right? Now, again, it says another thing that mere receipt or retention of premium, which means if you are receiving or your retention of premium is there until after the death of the applicant, if only this thing is happening, then it is not an acceptance, right? You have to have that particular insurance contract with you, right? Without that, if you are having only receipt or retention of the premium, then that is not a valid contract. That cannot be called as an acceptance, right? Now, one more thing is that from which date it will be valid. So, for example, if the policy date is 12th of October 2023, right? So, it would cover the liability of the insurer from the midnight preceding the same date. Midnight preceding the same date means from uh, 12th October 2023 रात के 12 बजे से, which means 12 a.m. we are talking about 12 a.m., right? So from that midnight, it would cover the liability. Like from that midnight, if something happens, then only the liability will be covered by the insurer, right? If time of issue of insurance policy is mentioned, if time of issue is mentioned, then obviously the liability would be covered from that time only, right? This is a common sense. Now, if any special contract to the contrary in the policy, then special contract will prevail, right? So apart from the insurance contract, if you are having any other special contract which is contradicting the terms and conditions of the policy, so in that case whatever terms and conditions mentioned in the special contract, that will only prevail, right? I think up to this everything is clear. Okay, Lalita is saying yes ma'am. Very nice. So Lalita, is this your first class taken by me, or you had joined in the earlier two classes also? Okay, this is the first class. So you can watch the other two classes on my page on Unacademy. So those two classes are also available. So you can watch them in your free time. Okay. Okay, and now these are the interesting part of the insurance law. But in our ICMAI book, some very boring things are also given there in long paragraphs. So I have converted them into bullet points, which will help you in understanding the concept in a better way, right? So now we are going to start with the provisions related to insurance. Now, the first provision says that Indian properties not to be insured with foreign insurers without the permission of the IRDAI. So now this particular thing is very important. This word without, this is not saying that you cannot insure Indian properties with foreign insurance companies. It is saying that to do so, you have to get the permission of Insurance Regulatory and Development Authority of India. Without the permission, you cannot do any insurance for your Indian properties with a foreign insurer. Right? Now, the next point says that no person shall take out or renew new policy. Nobody can do this, right? Nobody can take out any policy, or nobody can renew any policy regarding a property, ship, vessel, aircraft which is registered in India. Now this is important, which is registered in India, right? So all the property includes your ship, vessel and aircraft also, right? Along with your movable, immovable properties, all these three things are also included. So no person can renew any policy or can take out any policy regarding all these things if they are registered in India, right? With an insurer where the principal place of business is outside India, which means obviously no Indian person can no Indian or no person can do any insurance with a foreign insurer regarding any property, ship, vessel or aircraft which is registered in India, right? Now this must be clear to you. बहुत easy था. Now the next thing is also very important when we think of MCQs, right? Because institute can ask MCQs from anywhere, and those MCQs are for 2 marks, right? You, if you are under old syllabus, then you have to write the answer and then you have to give a justification. But if you are under new syllabus, then you simply need to write the answer according to the new MTP issue, right? Now we are talking about the requirement of capital of the insurance companies which are registered in India, right? Indian insurance companies. Minimum PUSC, that is your paid up share capital required, which exclude this amount excludes the preliminary expenses which are incurred during the incorporation or registration of the company. So excluding all those preliminary expenses, what is the minimum paid up share capital requirement? So when the insurance company is dealing with only life insurance and general insurance, so in that case, the minimum paid up share capital should be 100 crores, at least 100 crores, right? At least 100 crores. And when we are talking about the insurance company which is dealing with health insurance, exclusively health insurance, right? Not anything else along with health insurance. So in that case, again, it is the same amount. 100 crores should be the minimum paid up share capital. Now, the third point says that reinsurer company. What is reinsurer? In the last class only, I told you while studying the definitions that it is very similar to your the concept of subcontracting, right? So when the company is exclusively dealing with reinsurance, so in that case, the minimum paid up share capital amount is 200 crores. But here it says that it shall not be registered, like this reinsurance company shall not be registered unless he has net owned funds of at least 5,000 crores. 5,000 crores is what net owned funds by that reinsurance company. Why is it, why another condition is given here? Because in case of reinsurance, the risk is more, right? For the reinsurance companies, the risks are more. So that is why an extra condition is given, which talks about the net owned funds should be at least 5,000 crores. Now, the insurer may enhance the PUSC, which means the insurance company may increase the minimum amount of paid up share capital according to the relevant provisions of the Companies Act and SEBI Act, right? They can increase, obviously, they can increase the amount of paid up share capital, right? Now, further conditions that we need to study is that to carry on any life insurance, general insurance, health insurance, or reinsurance business, the following requirements also need to be satisfied. The first requirement says that the capital of the company means we are talking about the insurance company, shall consist of equity shares, each having a single face value. We all know what is the meaning of face value. So it says that the equity shares of the company should have a single face value, and the capital of the company can have other form of capital also, like debt or preference shares, as specified by the regulation. If the regulation allows that, if the regulation specifies that the capital of the company can be equity or debt or preference share, then it can be done in that manner, but it should be according to the regulations. Now, this is mentioned in section 6A of 6A of which act? Do let me know that which act we are studying now. Shivani and Lalita, do let me know. Our syllabus is having two parts, part A and part B. So I think Shivani can answer this. Yes, Insurance Act 1938. Very nice. Now, the second condition says that VR means voting rights, right? Voting rights of shareholders are restricted to equity shares. Obviously, right? The voting rights will be restricted to equity shares. This is a very basic thing. And now the third point is important. We will like read this third point from the end. It says that the paid up amount is the same for all the shares, right? The paid up amount is the same for all the shares except during any period not exceeding 1 year allowed by the company for payment of calls on shares. So this says that the paid up amount will be same for all the shares, but if the company wants, then the company can provide a period of up to 1 year, not more than 1 year, for the payment of calls on shares, right? So these are the three important points. The first point says that the capital of the company shall consist of equity shares having single face value, and other forms of capital also if the regulation specifies that. Second point is that voting rights only for equity shareholders. Third point says that paid up amount is the same for every share, but if the company wants, if the company allows, then in that case, what happens? The payment of calls on share can be held up to 1 year, right? Up to 1 year. Now, the next point says that above conditions not applied on a public company. Although all the three conditions are not applicable on a public company, which means a limited company which has issued any other shares except equity shares having a single face value. Any other shares except equity shares having a single face value, or a paid up amount which is not the same for all of them for a period of 3 years from such commencement. So it says that the if any public company has issued which means in a registered stock exchange, the public company has issued any other share other than your equity share having single face value, or the public company has a paid up amount which is not same for all of them, from the from for a period of 3 years from the commencement of this commencement of the issue of shares. So in that case, all these above conditions will not be applicable on that public company, right? I think this is clear. Now we are going to study the audit of accounts of insurance companies. This is very boringly written in ICMAI book. So this is mentioned in section 12 of the Insurance Act 1938. It says that unless subject to audit under the Companies Act 2013, uh, all these four things should be audited annually by an auditor, right? What are the four things? Obviously we know that one is the P&L account and second is the balance sheet, and in case of insurance company, obviously the revenue account is also there, and profit and loss appropriation account is also there, right? So, for every insurance company, an auditor shall annually audit these four things: balance sheet, profit and loss account, P&L appropriation account, and the revenue account. These four things shall be audited annually. Now, the auditor shall, in the audit of all such accounts, have the powers of an auditor under Companies Act 2013. So, whatever powers of of an auditor are mentioned in under your Companies Act 2013, all those powers are with the auditor while doing this auditing, right? This is also a basic thing. Now, what are the powers or what are the duties of the auditor? The first point says the auditor can exercise the functions vested in. He can exercise the functions vested in, which means this auditor is having all the powers which are officially given to him under the Companies Act. Whatever powers are given to him, he can use that, right? So he can exercise his powers to make the functions, to execute the functions, right? Now, the second point says that the auditor can discharge the duties, which means the auditor can do everything that needs to be done by an auditor in a particular situation, right? Now, the third point says that auditor is also subject to liabilities and penalties imposed on auditors by section 147 of the Companies Act 2013. Now, obviously, if the auditor has been given certain powers and certain duties, then obviously, along with powers and duties, some liabilities and penalties will also come to him, right? So, auditor is also liable to some liabilities and penalties which are imposed to him under section 147 of the company law, right? Now, this is we studied the audit of the accounts under section 12. Now we are studying submission of reports under section 15. Now this says that uh, audited accounts and statements, audited accounts and statements, and the abstract and statements under section 13. What is this? This we will study after this particular section is done, right? So these things shall be printed, and four copies of these things shall be furnished as returns to IRDAI within 6 months from end of relevant period. So, for whatever period it pertains to, from the end of that period, let's say it was for the last financial year. So, 6 months from the end of last financial year means April, May, June, July, August, September, right? So, within September, yeah, very nice. Shivani is saying September. So within the end of September, the four copies of all these things shall be furnished as returns to IRDI, right? And out of these four copies, one shall be signed by the auditor or the actuary, as the case may be. Now, what is the meaning of actuary? Actuary means there is a study called actuarial sciences, which generally, yeah, actuarial. So actuarial sciences is what? it generally evaluates the insurance risk or the risk attached with insurance. Yes, very nice, Shivani. So risk attached with the insurance. So the person who evaluates all those things is known as an actuarial officer. So one copy should be signed by the auditor or the actuary, as the case may be, and one copy shall be signed by the chairman or the principal officer, two directors of the company, and managing director if there is any. Right. Now this was also very easy. Now we are going to study section 13 of the Insurance Act, which talks about actuarial valuation or report. So actuarial valuation should be done at least once every year. हर साल में एक बार होना ही चाहिए. Every insurer carrying on life insurance business shall cause an investigation of the life insurance business which is being carried on by him, including a valuation of his liabilities in this regard. Right? So every insurer who is carrying on an life insurance business has to do an investigation of that particular business, including a valuation of his liabilities. Liabilities means in case of contingency or in case of like what are his liabilities, and like how many policies are there in which he might have to pay. All those things the insurer have to maintain, like he has to conduct an investigation in which all those things shall be written. So it should be done at least once every year, and shall also cause an abstract of the report of such actuary to made in accordance with the regulation. So whatever regulation is specified, according to that, one abstract of the report shall also be made. So here in this, in the last provision, we studied that the abstract and the statements under section 13. So obviously, so it means actuarial valuation report and the abstract of such report shall be made according to the regulation. Right. Now IRDI may allow any insurer to have investigation to be done within 2 years from the date as at which previous investigation was made. So it says that IRDI may allow any insurance company, depending upon the situation, uh, where the allowance is what? From the previous investigation, from the date of previous investigation, within 2 years you can do the investigation. Right. Like it has to be done every year, but in case you have to if the IRDI permits, then you can conduct that within 2 years. Right. If investigation is done annually by insurer, if it is being done annually by insurer, then statement need not be attached every year. अगर हर साल हो रहा है, that means it need not be attached every year, but uh, at least once in every three years it should be attached. So which statement we are talking about? The actuarial valuation report and the abstract we are talking about, right? So if the investigation is conducted every year annually, so in that case, every year you do not need to attach the report, but it should be attached at least once in every 3 years. Right. Now, now the next thing which we are going to study now is section 14, which talks about records of policies and claims. Now, every insurer, in respect of all businesses transacted by him, has to maintain or shall maintain a record of policies. So, record of policies means who is the policy holder, like to whom the policy has been issued, what is the effective date of that policy or issue date of that policy, and also a record of any transfer, a record of any transfer or nomination. So, what are the things? Basically, it means if you don't remember these things in the exam, so you can simply write the details. And obviously, when we are talking about policies, you can remember the name and address of the policy holder, obviously. And the second thing is that the effective date of issue of that policy. And the third thing is that if any transfer or nomination is there, or you can simply write if any modification of the policy is there, then you can also write that, right? Now, so these are the records of the policy. Now the next point says a record of claims also. So claims means in case of maturity or in case of happening of a particular event, in that case what happens, every like claims are made. So every claim made, you have to maintain a record of every claim which has been made to you, every claim which has for which the insurance company had to pay an amount, right? So you have to mention those things. And apart from that, the date of claim, on which date the claim has been made, name and address of the claimant, obviously, date of discharge of claim, date and ground of rejection if any rejection has happened. Now, when you go, if you get this question in the exam, then what are the things which we can remember from our common sense? The first is every claim which is made, obviously, date of claim. The third is the name and address of the claimant, and lastly, if any rejection has happened, then what is the date and what is the reason of rejection, what is the cause of rejection, right? Why the rejection has happened. So these 3 points we can obviously remember. These are out of common sense, and you only need to remember the third point, right? अगर भूल भी गए तो कोई बात नहीं, right? Now, all the above records may be maintained in such form, including electronic mode, as may be specified by regulations. Right? All these records can be maintained in hard copy and also in soft copy, as may be specified by the regulation. Right? I hope this is clear. Okay, Tawfiq has joined. So we have actually covered everything. Yeah, Shivani is saying that yes, it is clear. Okay, so I think we will need two more classes because the IRDAI, which is the second part of our syllabus, that has a very small portion, and that also includes some very basic things like functions of IRDAI, roles, and all those things. So we can complete that in one class, and whatever boring things are remaining in the part A, that I think we will cover in the next class, right? So let's keep this class up to here, and I am thinking of conducting the next session on 19th of October, which is on which is a Thursday, I think. So the timing will be same. Okay, Lalita is asking how can we get this notes, ma'am. Okay, so Lalita, after the completion of this entire series of insurance law, you can ping me on Telegram, or you can send me an email on my email ID, which I'll provide here, and I'll provide you with this particular PDF.